So it'll start right at noon your time, right on the hour, right?
Yeah.
I was looking around because the last time I did a Zoom, they started drilling directly below my office at the same time I was talking. And someone just knocked on my door and I was afraid they were going to tell me same thing's happening, but no, we're in luck so far.
Yes, since the quarantine, I'm very much more aware of all of the landscaping that happens at various times all throughout the week. There's just cacophony of leaf blowers and weed whackers.
So you have leaf blowers too? Yeah, that's a major problem. I've actually emailed the head of the leaf blowing department here at Vanderbilt because it's been so outrageously noisy.
Tell him to cease to desist.
It smells too. The fumes from the leaf blower.
It does.
Permeate everything.
Okay, so we have about 200 folks joined now. I'll make a few quick announcements and hand it over to Simone. So greetings, everybody. My name is Rachel Hasna. I am with UNM's Division for Community Behavioral Health. Welcome to our Law and Mental Health didactic series and Happy New Year. Thank you for joining us. In terms of our CEU process, in order to qualify for CEUs, we will need to be on for the full hour in the chat. So if you look at the bottom menu of your screen, there is a chat icon. That is where we will submit the link for the evaluation. You'll fill out that evaluation. When you are done, a certificate is automatically generated for you. It is your responsibility to save a copy. So save it to your computer. If you're on your smartphone, take a screenshot of the document. You can also email it to yourself. If you're joining us by phone, you can send me an email and I will make sure that you get the link to the evaluation. We are recording and we'll have the Zoom link available as well as a copy of the PowerPoint closer to the end of the week. And if you have any questions, please submit them in the Q&A. And I'll hand it over to Simone.
Thank you, Rachel. All right, so welcome to the University of New Mexico Law and Mental Health Didactic Series. So this series is hosted by UNM Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Sciences Division. So we're so glad to have you all joining us today. My name is Simone Fullion. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. First, I just want to announce that we are accepting applications to our forensic postdoctoral fellowship. We have 2 spots and there's just a few short days left to apply. Our deadline is January 14th. We also just got approved for the 5-year waiver, which we're really excited about. If you would like a copy of our brochure, it's ready to roll. So just you can email me. We also have a website that has the brochure and additional information about the postdoc. Next, I want to remind you that next week we have Dr. Sarah Desmarais, who will be presenting on pretrial risk assessment in the context of bail reform. So please join us for that presentation. For our talk today, as usual, for many of you that join this seminar every week, we're going to be holding questions towards the end. You can put them in the Q&A at any time. So whenever you think of the question or you feel comfortable, but just know that we're going to be saving the questions for the end. Also, we always try our best to get to all of your questions, but sometimes we just don't have enough time to get through everybody's questions, okay? Dr. Slobogin has agreed to stay on a few minutes extra, but we want to be respectful of his time. So for that reason, we don't always get to everybody's questions. So we apologize in advance. Also, for those of you that want the CEUs but are on a tight schedule, the requirement is to stay the full hours. So a couple minutes before 1 o'clock, we will be posting the CEU link, and then I will also come on and let everybody know, for those of you that need to jump off, that that's the time to do it. But as I said before, we will be staying on a little bit longer after the hour to answer some questions. Okay, so with all of that housekeeping out of the way, it's now time for what we've all been waiting for. I'd like to introduce our speaker for today, which is Dr. Christopher Slobogin, which really frankly needs no introduction. We're so thankful and grateful for you to present today for us. I know personally you have been a huge influence in the way that I think about forensic evaluations and presenting evidence to the courts. And so some of your work has really been very influential for me personally. So thank you again. I had a little bit of a fangirl moment there. I apologize. But So Chris Slobogin occupies the Milton Underwood Chair of Vanderbilt University Law School. He is a co-author of Psychological Evaluations for the Courts, Guilford Press, Minding Justice, Harvard University Press, and Proving the Unprovable, Oxford University Press, and scores of articles on mental health law, as many of you know. So without further ado, on behalf of UNM and the Department of Psychiatry and Behavioral Sciences, thank you so much, welcome, and we are looking forward to your presentation today. And with that, I'm going to go black.
Okay. Thanks, Simone. Thanks, Rachel. It's been great being able to do this program with you. I'm looking forward to discussion on the title that you see here, The Ultimate Issue. Before I get started, some of you may have been on the Zoom call already when I mentioned to Rachel that we have a leaf blower problem here, and I was joking about it, but believe it or not, literally 15 seconds ago, a leaf blower started blowing leaves right outside my window. I told him to move on. Let's hope he stays away. We'll see what happens. So far, okay, but we'll see if he treasures his job over ruining the Zoom call. So, again, the ultimate issue. The reason I think this is interesting to talk about is because not only is it a specific issue that mental health professionals who testify have to grapple with, but it's also an entree into a larger discussion about testimony from mental health professionals, exactly what they should and should not be saying in the courtroom when they have an opinion. On the specific issue of the ultimate issue, there has been a lively debate about this for some time amongst mental health professionals, lawyers, and academics. Many commentators, a good portion of whom are academics, but also the American Psychiatric Association, the American Bar Association, and Congress through the Federal Rules of Evidence have all insisted on a prohibition against any language in clinical testimony or reports that embraces the ultimate legal issue. On the other hand, a number of others, including a large number of forensic specialists, as well as practicing lawyers, just as firmly believe that ultimate issue testimony should be permitted. So this is the debate that's been going on for some time. What I'm going to advance as a position is, and it's typical of a law professor, right? It depends. It depends on the setting in which the testimony is being presented, whether we should allow ultimate issue testimony to occur. I want to start by defining what ultimate issue means, and I want to make a distinction between ultimate issue testimony and penultimate issue testimony in language. An ultimate conclusion directly addresses the dispositive legal issue, that is, whether a person's incompetent, insane, or committable. And by the way, I'm going to focus on the criminal justice system and testimony in the criminal justice system, but a lot of what I have to say could also as easily apply in civil cases. It's just that this comes up more often in criminal cases. So that's ultimate issue testimony. In contrast, penultimate testimony is the phrase I use to refer to the relevant legal test. So, for example, testimony under the American Law Institute test for insanity, which probably most of you know about, to the effect that a person accused of crime does or does not have a mental disease or defect that results in a lack of substantial capacity to understand the wrongfulness of the act or conform behavior to the requirements of the law. Now, the reason for making this distinction between ultimate issue and penultimate issue testimony will become clear later. For now, I just want to get across the confusion the courts have on this issue. Here are two examples. You've got United States versus Christensen, where the court held that it was permissible for the expert to say that because of mental disability, the person lacked the ability to appreciate the nature of his actions. On the other hand, you got United States versus Manley, where the court held it was impermissible for the expert to say the individual could appreciate the nature or wrongfulness of their actions. If you look at the case law, you get decisions that either directly or at least indirectly conflict with one another. The courts are unclear as to precisely what kind of language is permitted by experts. Even in the federal courts, where there's a specific rule, Rule 704, which bars ultimate issue testimony. So this is what we'll be talking about. But again, I want to broaden the issue eventually to the extent to which mental professionals ought to be able to deliver opinions in a general sense. So let's start, though, with the ultimate issue debate, the debate over ultimate issue and penultimate issue testimony. And I want to start by canvassing the arguments against ultimate and penultimate testimony. And there's several of them. So most fundamentally, it's argued that, that this testimony is not properly the province of mental health professionals. The federal rules of evidence, which I've already mentioned a couple of times, state that a witness may offer an opinion only on those subjects concerning which he or she is, quote, an expert by knowledge, skill, experience, training, or education. Reaching the ultimate legal conclusion on or applying a legal test for competency, insanity, and committability calls for a legal moral determination, not a psychiatric one. So you could say that under the federal rules of evidence, and by the way, most states have identical language, an expert who uses ultimate or penultimate issue language is not basing his or her testimony on knowledge, skill, experience, training, or education, because these are legal moral issues, not clinical issues. So let me give you some examples of what I'm talking about. Let's say the issue is competency to stand trial. Even if a mental health professional finds, and no one disputes, that the defendant's ability to interact with the attorney and understand the courtroom process is significantly compromised, a finding of incompetency may not be appropriate. The ultimate determination as to whether a person is competent is very context dependent. Thus, for instance, if the charge against the defendant is a simple one to defend, let's say, and this is occurred in a case that I actually was involved in, the charge is driving without a valid license, for which the prosecution need prove only that the defendant was driving a car with a suspended license. Even a severely disturbed individual may be considered competent because the attorney needs little assistance from the accused in defending that kind of case. Psychological information should rarely be determinative of the legal issue of competency. Other factors having nothing to do with the individual's mental state should and often do play a pivotal role in the ultimate decision. The same is true when the issue is the insanity offense or commitment. In fact, it's probably more true in those two contexts. In the insanity context, for instance, the degree of impairment sufficient to excuse an individual for an otherwise criminal act is a moral judgment. It's not a scientific one. In addition to the information provided by the expert, the fact finder, and of course this could either be a jury or a judge, the fact finder deciding whether someone's insane might be influenced by the seriousness of the crime, the identity of the defendant, and most importantly, an intuitive sense as to the types of impairment that should be grounds for an excuse. Similarly, in deciding whether someone should be committed, once predictions are made about the type of act a person might commit, the likelihood it will occur, and whether confinement or treatment will prevent it, the judge jury must consider how these predictions interact and balance the result against the person's liberty interest. Again, the type and degree of dangerousness necessary to justify involuntary confinement is ultimately a moral judgment, not a psychiatric or psychological one. So that blends into the second argument against ultimate issue testimony. Certainly, and I'm sure this is true of most of you, because of what you do for a living, mental health professionals are capable of making moral judgments on the kinds of issues I'm talking about. But the point is that making these judgments is not their field of expertise. That's the important point. Mental health professionals are not trained as our judges, nor institutionally qualified as our juries to reach legal or moral conclusions. They may have studied the relevant legal tests, but they are no more experts in the law than lawyers who have studied the most recent medical texts or experts in the behavioral sciences. So the argument goes, they should refrain from addressing the ultimate issue in their capacity as experts. In fact, it has been argued, as the slide shows here, it would be unethical to do otherwise. It would be unethical to address the ultimate and penultimate issue. Another argument against this kind of testimony, it has to do with the concern that if such testimony is allowed, it will have undue influence on the fact finder. Out of inertia or a misunderstanding of its role, the fact finder might rely on the expert's opinion about the legal conclusion instead of independently assessing the many factors that go into legal decision making. This danger is exacerbated if the willingness of the expert to provide an ultimate conclusion and the eagerness of the fact finder to hear it minimize efforts to examine the basis of the conclusion. The opinion on the ultimate issue may come to assume disproportionate weight relative to the underlying facts in the mind or minds of the fact finder because the facts are not developed or not properly emphasized. Those of you who do this kind of stuff may have had the following experience. I know that when I train mental health professionals in the state of Florida, I hear this from them all the time. They do a great report on, let's say, competent to stand trial, 5-6 pages long, single space. They give it to the judge. What does the judge do? Turns to the final page. Doesn't even bother reading the first 5 pages, just flips to the ultimate conclusion. That's the concern, that judges will abdicate their responsibility for making the ultimate conclusions to the expert. And finally, there's this argument against avoiding the ultimate issue, against ultimate issue testimony in favor of avoiding ultimate issue testimony. And that is that the battles of the experts might not be as common. That is because if there's no ultimate issue testimony, each side will be more likely to find something that they like about the opinion. And so there won't be as much adversarialness involved in the litigation. So those are the arguments, at least most of them, against this kind of testimony. But of course, there are a number of counter-arguments. There are several of them. First of all, there is the contention that at least with respect to the penultimate language, the legal test language, the terms involved are within the professional lexicon of the clinician. So for instance, you all know the insanity language in the American Law Institute test, and also in the federal test for insanity, a person's ability to appreciate the wrongfulness of certain acts, which is what the insanity defense is in federal courts in many states, or relate to an attorney, which is a language you often see in competency formulations, or refrain from committing dangerous acts, dangerousness being a word that's seen in many commitment statutes. All of those words do have clinical content. Merely because they may also have legal significance does not mean that by using them in a legal proceeding, the mental professional is no longer testifying on the basis of specialized knowledge. In the original criminal justice standards, adopted in 1995 by the American Bar Association, this point was recognized, at least in the context of insanity. What the ABA said was this: it still unconditionally barred truly ultimate testimony, that is, testimony to the effect that the person is sane or insane. But it allowed the penultimate legal language to be used by an expert. In other words, the ALI language for the insanity defense could be used by the expert with one caveat. It said if the legal test language had been given a specific meaning by statute or appellate decision, then it could not be used. So only if the law had defined, let's say, what the word appreciate means, could the expert not use it. Otherwise, the expert could use it, assuming it had some clinical content, some clinical meaning to the expert. Now, the new ABA standards, which were adopted in 2016, 20 years later, say something different. I'll get to that a little bit later. So the first argument is, hey, come on, the language that the law uses also has clinical content. Experts ought to be able to use it. A second argument against an ultimate issue ban is that even if certain languages does take mental professionals beyond the boundaries of their expertise, the opinions that they may legitimately voice will often be such close approximations of a legal test that one might as well allow ultimate issue testimony anyway. For example, a ban on ultimate and penultimate testimony would not prevent a mental professional in an insanity trial from stating that he or she believed the defendant said something, the defendant's problem was something like this, quote, impulse control, the defendant's impulse control was severely impaired at the time of the offense. That would be language that the expert could clearly use, even with an ultimate and penultimate issue ban. Yet this statement is remarkably similar to the language of the LI test for insanity, which asks whether the person possessed, quote, substantial capacity to conform his or her behavior to the requirements of the law. The first statement is based on the clinician's specialized knowledge and is therefore proper expert testimony. And if that kind of statement can be made by the expert, then borrowing testimony that uses the actual test language will accomplish very little. And even if we prohibited paraphrasing, imagine what a mess that would be. So we can't paraphrase either. That's not going to be a solution because we can depend on the ingenuity of lawyers and mental health professionals to work around it. So that's the second argument against a ban on ultimate issue testimony. And third is that any tendency of experts to use this language to somehow dominate the process can be combated in the ways that you see here. Even if the expert uses ultimate issue language over and over again, attorneys through cross-examination, rebuttal experts, instructions to the jury that what the expert says is not dispositive of the legal issue, all of this can counteract any bad impact that comes from ultimate issue testimony or penultimate issue testimony. And of course, experts can always preface their opinions that they do give with the observation that what they're about to say is based on their interpretation of the legal text. It is not meant to be dispositive of the issue. So those are, I think, the main arguments, the negative arguments, basically counter arguments. There's also a positive argument for allowing ultimate issue testimony. And that is that such testimony can help organize and clarify the expert's evidence for the fact finder. Without a conclusion, the fact finder might have difficulty discerning the clinician's position, and thus might not be able to make sense of the testimonies easily. Or maybe the fact finder will be able to correctly guess the clinician's position, given the content of the testimony or the identity of the party who's calling the expert, but feel that because the expert's not straightforwardly stating a conclusion, he or she is trying to hide something. Prohibiting ultimate issue testimony might, in that kind of situation, unfairly detract from the credibility of the rest of the testimony. And in fact, the available research strongly indicates that judges, lawyers, and juries all want ultimate issue testimony from the expert. And this, I guess, is the final reason. It's the practical reason. And in fact, this reality may be the most powerful reason for allowing ultimate issue testimony. And that is that the people in the legal system who use clinical testimony want ultimate issue and penultimate issue testimony. Many of you may know Norman Poythress. He's someone I worked with for years. And he made the point very graphically in an article that appeared in Law and Human Behavior after he tried to avoid using ultimate issue testimony in an insanity trial. And I think the first sentence of his article makes the point very clearly. This is the first sentence. I'm popping my third beer as I sit down to write this article. Suffice to say that Norm, in trying to avoid ultimate issue testimony, had a very unpleasant experience. The judge could not believe he was avoiding the issue. Lawyers were adamant that he should testify on the ultimate issue. And so he had a tough time. He stuck to his guns, but it did not go well. And I think his article makes the point I'm trying to make. Just as a practical reality, legal actors want ultimate issue testimony. So that's the debate. And I think there are good arguments on both sides. Let me give you my view, which, as I said before, is sort of in between. I think there are plausible aspects to both points of view here. Those who want to bar ultimate issue testimony, I think, have a particularly strong argument when the testimony is truly ultimate. Terms such as insanity, competent to stand trial, or the person's committable are solely legal. They are not phrases that a mental health professional would use in everyday practice. They have no psychiatric or psychological content. So their use will not only gloss over the ultimately moral nature of the determination at issue, but also violate the notion that expert testimony be based on specialized knowledge. On the other hand, the legal test, the penultimate issue language, often contain language that is meaningful to mental health professionals in their expert role. So my view, contrary to the 1995 ABA standard that I talked about earlier, is that so long as a term has clinical content, the fact that it has also been given specific legal meaning as well should not prevent it from being used by the clinician. For instance, a decision by an appellate court defining appreciate, the word appreciate in the insanity test, to mean emotional understanding, let's say, should not preclude mental professionals and insanity trials from using the word appreciate so long as they make clear to the fact finder what they mean by that term. Borrowing such testimony would merely lead to paraphrasing, perhaps ironically using the word understand in place of the prohibited word appreciate, and probably end up confusing the fact finder. The conclusion that a blanket ban on legal test language with clinical content is inappropriate, which is what I just went through, does not mean it should be permissible in every type of legal proceeding. However, this is where I contextualize things a little bit. This is the it depends point that I'm trying to make. I think such language, penultimate language, should be allowed only if the protections against undue influence that I described earlier, cross-examination, rebuttal evidence, cautionary instructions, that kind of thing. Only if those protections against undue influence are actively used in the proceeding. When they are not, when lawyers are either not present or passive, the likelihood that the fact finder will fail to assess the factual basis of the expert opinion or adequately consider non-clinical or moral factors increases dramatically. Instead, there's a great temptation to accept unquestioningly what appears to be the bottom line, the expert's opinion on the ultimate and penultimate issue. Now, granted, any failure to abide by the adversarial tenets of the system is the fault of lawyers and judges. They're the ones that should be making sure the process is adversarial. It's not the mental health professional's fault. But we should not allow clinicians to exacerbate this failure by sanctioning their presentation of ultimate issue testimony in such proceedings. In a full-blown insanity trial, usually it can be assumed that the procedural protections I'm talking about against expert dominance will be present. Cross-examination, rebuttal witnesses, and instructions are commonplace in the typical full-blown insanity trial. But the majority of proceedings in which forensic issues are decided are far from adversarial in the way that I just described. For instance, civil commitment, as many of you know, is pretty informal, and competent proceedings often don't involve any kind of hearing whatsoever. And especially in the competency context, the judge often relies on written reports rather than live testimony. Even most insanity findings are the result of plea bargains that receive only minimal attention from the judge. So if it's a full-blown insanity trial, the adversarial process is present, but as many of you know, in some jurisdictions, 70 to 90% of all insanity verdicts are based on reports or very bare bones kind of hearing. So permitting ultimate and penultimate language in these kinds of proceedings is much more suspect. In fact, I would say that in any non-adversarial setting, any kind of conclusory language, not just ultimate or penultimate testimony, is more likely to assume undue influence. So an argument can be made that in such a setting, much of what is currently accepted as expert testimony should be significantly curtailed. And this is where I'm getting to that broader point that I was alluding to earlier. So to understand a little bit better what I'm talking about, clinical testimony can be seen as a progression through several levels of influence. So let's take an insanity case, for instance. You could think of testimony on insanity as constituting 5 different levels of influence. And here I provided examples of those 5 levels. Now you can actually come up with 6 or 7 levels if you want. I've simplified it a little bit. First level is just fact, okay? What facts did the expert learn from the defendant? Well, during the evaluation, the defendant said he or she was hearing voices, both at the time of the evaluation and the time of the alleged crime. From that, the expert could draw an inference. Well, based on those facts, I conclude that this individual is suffering from hallucinations. In other words, a symptom description can be given by the clinician. Then the expert might go from there, making a further inference. Well, because of these symptoms, the person has a diagnosis of schizophrenia. And in fact, I would go further than that. The expert might say and formulate that at the time of the crime, because of the hallucinations and the diagnosis of schizophrenia, the individual had an impaired ability to understand what was going on at the time of the crime. The next level of inference could be the penultimate language. Because of what my formulation is, I believe the person could not appreciate the wrongfulness of his actions. And then finally got the ultimate language. Because of that, I think the person was insane. Okay? So that's one way of thinking about insanity testimony through increasing levels of inference, beginning with the facts and going all the way up to the ultimate issue. Now, many practitioners would say all 5 of these levels are fine. We can talk about facts, symptoms, diagnosis, formulation, penultimate language, ultimate language, no problem. But many academics, and apparently the ABA and APA, at least in insanity cases, would only permit levels 1, 2, and 3. With few exceptions, all parties would allow levels 1, 2, and 3. Some would not allow levels 4 and 5, but all would allow levels 1, 2, and 3, or almost all. But there is one exception. Some of you have heard of Stephen Morse. He's a well-known psychologist and lawyer who's written on many topics having to do with mental health law. He would bar testimony on all of these levels except for the first one. Okay, that's his point of view. All of these levels would be out of bounds except for the first one. His rationale is that at any of the levels above the first one, mental professionals do not possess specialized knowledge sufficient to assist the fact finder and therefore are not qualified to offer opinions on such subjects. They might have specialized knowledge on symptoms and diagnosis, but that information does not assist the fact finder. Once the jury or the judge hears the facts, they don't need to hear the rest of it. Now, I happen to disagree with Morse, and during Q&A, if you want to talk about it, we can, but I'm not going to go into my disagreement now. I disagree with this assertion that experts should not be able to testify at all past level 1. But I do agree with him that as you go up this inferential chain from facts to ultimate opinion, the inferences get more and more speculative, okay? The leap from facts to symptoms is somewhat speculative, from symptoms to diagnosis, more speculative, and so on. And when the legal proceeding in which the clinical testimony report is being considered is non-adversarial in nature, such speculative clinical testimony, because it will go unchallenged, is decidedly more likely to lead to invalid decisions. Especially risky is untested testimony that is directly relevant to the legal issue, that is levels 4 and 5. And therefore, that testimony is most likely to influence the legal fact finder because it's unchallenged. Unless we can be reasonably sure that the fact finder will ask for and pay attention to information on all levels of the influential chain, rather than merely the most conclusive one, the latter type of testimony, that is testimony at levels 4 and 5, should not be allowed, given the suspect at the same time very alluring nature. So that's my sort of intermediate position on this. And in the end, and again, this is the broader point that I want to make, the ultimate issue debate is a subtext in the larger debate on the value of clinical testimony. In my view, the worth of such testimony is largely a function of how it's presented. The more ultimate such testimony becomes, the more energetic we should be in subjecting it to adversarial testing. Conversely, if such testing, including cross-examination of expert data and the submission of rebuttal evidence, is present, opinion testimony that's based on specialized knowledge should not only be accepted, but welcomed as helpful to the fact finder. But again, one major caveat to this analysis is that we have to, it places considerable faith in the well-functioning, in a well-functioning adversarial process and the competency and sincerity of clinicians. Perhaps lawyers cannot be counted on to explore the fallacies of clinical testimony, especially if clinicians are ignorant or unwilling to reveal those fallacies. To the extent this is true, I agree with Morse that even in adversarial proceedings, opinion testimony should not be allowed. I also believe, however, that lawyers and clinicians are becoming increasingly sensitized to the limits of clinical expertise, and that the adversarial process is a good way to ensure these limitations are made known to the fact finder. And regardless, as I've alluded to earlier, whenever a clinician does offer ultimate or penultimate testimony, they should be sure to couch that testimony in cautionary language. In fact, this is what the new ABA stands. Remember, I said there's some old ones from 1995. The ones adopted in 2016, you see the site here, says something different. It says the evaluator should use cautionary language to explain the boundaries of the expert's clinical expertise and the limitations of the opinion, whenever ultimate or penultimate issue language is used. So more specifically, and I assume a lot of you do this, the expert might say something like, the issue of whether the defendant is insane or competent or committable is not a scientific determination, but a legal one. However, based on my understanding of the legal test in this jurisdiction, the defendant is, and then you give your opinion as to whatever that opinion is. So that's a rundown of what I think the debate about the ultimate issue is and where I come out on it. I hope it's raised some questions about clinical testimony, opinion testimony generally. Be certainly glad to talk about that. There's also the very interesting case of Clark versus Arizona, where the Supreme Court indirectly said something about this. The reason I didn't bring it up during this presentation is that the court didn't say anything directly on it, but that's something we could talk about during Q&A as well, if you'd like. So open for questions. Yeah, I figured this would only be about a half hour, so that gives us at least a half hour, if you want it, for questions and discussion.
All right. So I'm going to start working through the questions. Okay, so the first one is rather lengthy, so hang in there with me because there's some federal requirements being cited here to help.
Get a pencil, okay?
I think it's just citing the federal rules of evidence, just as requirements so that it's helpful to keep in context. Right. So with respect to these issues and in reference to federal requirements, the following is stated in 18 U.S. Code 4247. So C, psychiatric or psychological reports. A psychiatric or psychological report ordered pursuant to this chapter shall be prepared by the examiner designated to conduct the psychiatric or psychological examination, shall be filed with the court with copies provided to the counsel for the person examined and to the attorney for the government, right? And shall include, so 1, the person's history and present symptoms. 2, description of the psychiatric, psycholegal, and medical tests that were employed and their results. 3, the examiner's findings. 4, the examiner's opinions as to diagnosis, prognosis, and ... And then A is if the examination is ordered under section 424, whether the person is suffering from a mental disease or defect. Oh,
the
sorry.
Last sentence
Can you
just broke up. You were fine.
The last sentence. Okay, great. So I think it's just for A. I'll just repeat A. So if the examination is ordered under section 4241, whether the person is suffering from a mental disease or defect, rendering him mentally incompetent to the extent that he is unable to understand the nature and consequences of the proceedings against him or to assist improperly in his defense. So obviously federal competency statute. And then B would be if the examination is ordered under section 424, whether the person is insane at the time. Okay, so that's the question is about C and B in particular. What is your take on the law is requiring / allowing in a report on sanity in the federal jurisdiction? And then, in fact, while you're answering that, the following question is, do you believe that determination of competency should be an adversarial question? So I think that those, so it's actually A and B might be relevant for discussion here. So competency and insanity.
Yeah, those are great questions. Well, obviously, one point I want to make is in no way, shape, or form am I advocating that you ignore the law. Okay, so in many states, what was just read is true in many states as well. The clinician is ordered by the court to address the ultimate issue, not just the penultimate issue, but the ultimate issue. And I'm certainly not suggesting or recommending that you ignore that. If that is the law, then what you see here in italics in the slide is what I recommend. That you say, look, this issue of competency or insanity is not a scientific determination, but a legal one. And you can say a lot more than what is said right here. This is just a very brief summary of what I think could be said. But once you make that first statement, however, since you're asking me, based on my understanding of the legal test in this jurisdiction, the defendant is, et cetera, et cetera. I'm referring to the reference slide here because this first reference, Gary Milton et al., I'm a co-author of this book. And by the way, I make about a nickel every time you buy it. So this is not really making any money by recommending this book. If you look at pages 601, 606 of the 4th edition, some of what I've said is elaborated on extensively, and it provides the types of language one might use in a jurisdiction where essentially you're required to give ultimate issue testimony. The point being, you just make it very clear that, look, I'm not a legal expert. I may be able to recite verbatim what the McNaughton test is or what the Dusky standard for competency is, but that doesn't make me a legal expert. It does not make me an expert on what insanity is or competency is. So take my opinion with a grain of salt and emphasize, again, instead of the ultimate issue conclusion, what your facts are, what your conclusions about symptoms and diagnosis are. That's the most important part of your opinion. The penultimate and ultimate parts of your opinion are not the most important part. Maybe lawyers insist on it because they want to bring home the adversarial point. But for the fact finder, the most important points ought to be, going back to what I had before, the first three levels here. Those are the most important pieces of information you can provide the fact finder. That should be the focus of your testimony. That should be what the fact finder focuses on, as opposed to the penultimate and ultimate language. And then I think the second, and if that doesn't answer your question, don't be afraid to rephrase it. But the second part of your question was, do I think competency proceedings should be adversarial? Well, if every competency proceeding were adversarial, we'd be in a mess, because that would be a lot of hearings, right? That is competency to stand trial, competency to proceed. Issues are raised more often than any other forensic issue, at least in the criminal justice system. And if we had a hearing every single time there was any kind of issue, any time the issue was raised, it would at least make for inefficiency and maybe actually create a serious backlog. So I'm not necessarily arguing for an adversarial process every single time there is any kind of issue with respect to competency. I think there should be one anytime experts disagree, anytime there seems to be any kind of serious issue, and even if there's not a serious issue, let's say there are three experts, all of whom come to the same quote unquote ultimate conclusion. I think all three of those reports should make it very clear in that last page of the report that this ultimate conclusion is based on the expert's interpretation of the legal standard and is not meant to be in any way, shape, or form a definitive statement on whether the person meets legal tests for competency.
Okay, so our next question. So the FRE says an opinion is not objectionable just because it embraces an ultimate issue, and then all caps, except in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime, charge, or of a defense. Those matters are for the trier of fact alone, end quotes. So this change was a knee-jerk reaction to the Hinckley case. Do you think that mental state opinions should be treated differently than any other type of ultimate issue unrelated to psychology or psychiatry?
Yeah, so these are both good questions. Obviously, people have a lot of experience with this. So the rule that was just read, Federal Rule of Evidence 704B, again, has a counterpart in most state jurisdictions, not all, certainly not all, but many. So the issue is, what does it mean exactly? And it was inserted after, and I think this is what the questioner alluded to, and the allusion is correct. This was inserted in the Federal Rules of Evidence after the Hinckley trial. You all know that John Hinckley was charged with attempted murder of President Reagan and so on, and then was ultimately found insane. Very controversial verdict, led to a change in the insanity language, the insanity test language at the federal level, also led to the change that we are talking about now in 704B. And again, what it says is an expert can address ultimate issues unless it has to do with insanity or what lawyers call the mens rea element of the crime, an element of the crime. And that would be in psychiatric and psychological context, mens rea for the crime. So that sounds like, at least to the untutored ear, that the only time an expert is not allowed to give ultimate issue testimony is when it's insanity or mens rea. Otherwise, you can give ultimate issue testimony. That's not actually what it says if you read the rules comprehensively. if you read them in total, because Rule 702, as I said before, says an expert may only give an opinion if it's based on specialized knowledge. So my reading of 704B is just reiterating that you cannot give testimony saying the person's sane or insane, or could not appreciate the wrongfulness of their act. Why? Not just because of some formalistic reason, but because it's not based on specialized knowledge. In other words, 704B is merely a specific application of what Rule 702 says. So let's say you have a tort case. Some of you probably don't do criminal stuff at all, but you testify in personal injury cases. One issue that comes up, of course, in tort cases is whether a defendant was negligent or not. In my opinion, and again, this is my opinion, an expert, regardless of what kind of expert it is, whether it's a medical expert, a psychiatric expert, an accidentologist, whatever, they should not be allowed to say the defendant was negligent. That's the ultimate issue. And even though 704B says you can reach ultimate issues, if you read that in conjunction with Rule 702, it says testimony has to be based on specialized knowledge. For all the reasons I've been going through in connection with this, I don't think the expert should be able to give an opinion that a person's negligent. It's not based on specialized knowledge because negligence is ultimately a legal decision, not a medical or clinical or accidentologist opinion. Now, again, if it's an adversarial process, if the expert makes very clear that it's their interpretation of the legal standard, then maybe that's okay. Usually in a tort case, it is going to be a full-blown trial with an adversarial process, rebuttal experts, instructions to the jury, and so on and so forth. But that's the way I would answer that question, is that 704B is merely a specific application of 702. It happens to single out insanity and mens rea testimony because it was written in response to the John Hinckley verdict. And as many of you know, statutes are often written in response to a single case. I think that's a poor way to do legislation, but that's the way legislation is often drafted. And that's all it means. I do have more to say about mens rea testimony, but maybe I'll hold off on that and see what other questions there are.
Okay, so next question is, so this person's asking if maybe you could share an example of a case in which this has been a particular focus or an issue for you to help sort of illustrate these issues.
Well, we could go back. I mean, these are actual cases, and we can go back to these actual cases. This is what happened in those cases. And in one case, basically the testimony is the same in both. They're a little bit different. But the testimony is the same. One court said can't do it. The other court said you can do it. So in the case where, in the Manley case, where the court said the expert can't do it, what could the expert say? Well, the expert probably, if there were a retrial, and by the way, this is reversible error, believe it or not, this is reversible error. There has to be another trial. If the expert testifies again, the expert might say something, well, he couldn't really understand what he was doing. Now, should that be prohibited? For all the reasons I've been saying, in a fully adversarial process, I have no problem with that, or even the language that was actually used in Manley. In a non-adversarial setting, I got much more of a problem. So again, if you want more specific examples, take the kind of case that many of you probably done over and over again, a competency case, where you think the guy is incompetent. If you had to reach the ultimate conclusion, say he's incompetent. I hope that what you do in those kinds of cases is 99% of the report is about the facts and maybe descriptions of symptoms and maybe some description of diagnosis. That's all relevant to whether the person is able to talk to the attorney and can understand the legal proceedings. And only a very, very small part of your report, if any, is devoted to the following issue. The person meets the Dusky test or the person's competent. I think that should be downplayed tremendously or not used at all in the report. Why? Because, as I said before, in most competency situations, the judge is just going to look at the report. There's not going to be any here, much less an adversarial contest like you have in a full-blown insanity case. That's the idea I'm trying to get across. I don't know if those examples are specific enough I hope they are, but if not, I can try again. Just let Simone know if you want other examples.
Okay, so the next question is, when you're referring to psychological in these issues, do you also include neuropsychological data / emails?
You're breaking up again.
Do you treat that information differently, or is it? Oh, sorry. Can everybody hear me now?
Yes.
Okay. Sorry about that. I must have a unstable connection. So the next question says, when referring to psychological, do you also include neuropsychological data / evals in this, or do you treat that differently, or is it all the same?
Yeah, it's all the same. Going back to these inference levels, a lot of the neuropsychiatric data would be the first level, right? You're getting readings on fMRI or some other neuropsychological source, and then you make inferences based on that neurological data. I think sometimes it's very hard to make inferences from neurological data, but it can be relevant in competency or insanity cases or civil cases. Certainly personal injury cases, it could be very relevant. So you got exactly the same issues. And again, when you go from diagnosis formulation to, oh, he was insane, or the defendant was negligent, or what have you, I think you're becoming much more speculative, and you get into troubled waters of the type I've been talking about. So there's no difference.
Okay. Do you have an opinion on testimony relating to the ultimate issue regarding sexually violent predator or sexually dangerous persons cases, either on the issue of mental abnormality, legally defined, or likelihood to commit subsequent sexual offenses?
Yeah, another great question, and a very good one. I think actually, as many of you know, it sounds like at least some of you do this, there are often very adversarial proceedings in these kinds of cases because so much is at stake. And the defense attorneys know that if a person is found to be a sexually violent predator, very often they could end up confined for a very, very long time, considerably the rest of their life. So it's basically short of the death penalty. It can be one of the highest stakes proceedings that the law has. So it can be a very adversarial process, in which case the concern about penultimate and ultimate issue language perhaps is not as great for all the reasons I've been talking about, is that there really is an adversarial process here. But having said that, I still think this is, if you will, not meant to be a pun, this is one of the most dangerous settings in which to give penultimate and ultimate issue language. The phrase mental abnormality, which appears in most of these SVP statutes, most of these sexually violent predator statutes, is incredibly vague. No one knows what it means. Supreme Court's had 2 cases in which it tried to define it and has done a horrible job. Statutes don't tend to define it. Basically, it's defined pathologically. A mental abnormality is something that makes a person predisposed to commit violent acts, sexually violent acts. Okay, so what? That's not a meaningful diagnosis. That's just tautological. It's saying you've got a mental abnormality if you're dangerous. And then you go to the second part of the statute, which is referenced, which is whether the person's dangerous, whether the person is likely to recidivate, reoffend, et cetera, et cetera. And there too, you've got a very dangerous situation. Why? Because the law does a horrible job defining what it means by dangerous. Most statutes say something like likely to commit sexually violent acts in the future, something like that. Well, what does that mean? What is a sexually violent act? Is it exposure, or is it a rape, or is it something in between? Does likely mean 51%, which is the way I'd quantify it if I was going to. Some of these statutes say something like, in fact, the death penalty statute, which I recognize is not a sexually violent predator statute, nonetheless it raises the same kind of issue. The Texas death penalty statute, as does the statute in 7 other states, makes dangerousness an aggravating factor in capital proceedings. And it defines dangerousness as a probability that the person will commit acts of violence in the future. What's probability mean? The law doesn't make it clear at all. In fact, Texas appellate law refuses to define probability. It refuses to even say that it has to be more than 50%. It could be 20%, it could be 10%. And these days with actuarial instruments, we actually have ways of quantifying this that we didn't have before. And yet the courts refuse us to give us any clue as to what is meant by this stuff. So that's all by way of that's all of a predicate to reaching my conclusion, which is ultimate and penultimate issue testimony in that kind of proceeding, even though it's adversarial, is very dicey, is very dangerous, because because you're an expert, there is a tendency to accept what you say as gospel. After all, what do they know about dangerousness? What do they know about mental abnormality? You're the person in three-piece suit with the MD or the PhD, and they're going to go with it and run with it because there's no good legal definition of what any of this means. At least insanity gives us some sense of what's going on. Competency, a pretty good sense of the legal definition. SVP statutes, horrific in terms of providing us with the legal definition. I'll say one last thing about this. A lot of my writing in the last couple of years has been aimed at developing what I call a jurisprudence of risk. A jurisprudence of risk. We have a huge amount of writing, what competency means and what insanity means, what culpability means. We have very little writing on what dangerousness means. And we need to do much more academic work, and certainly we need much more case law from the Supreme Court on down as to what all this means. Because we don't have it, ultimate issue and penultimate issue testimony is particularly problematic in that context.
Okay. So the next question says, can you comment on the penultimate and ultimate issues in terms of family court, specifically child custody evaluation recommendations? Yeah, that's a tough one.
Yeah, I was about to say I was going to use exactly your language. That's a very tough one. As most of you know, the language here is parental. Most states talk about parental fitness, and they might dress that up in various other terms. But that's the idea. The reason it's particularly tough is I've been talking about insanity and dangerousness as being tough issues. The custody is not only difficult because the criteria are not completely clear, but because, of course, it's such an emotionally fraught issue with both parents vying for custody of the kids, or at least joint custody. And I guess one thing I'll emphasize, and it's what I've already said with respect to criminal justice issues, is this is incredibly contextual, okay? Yes, the clinical information is very, very useful, no doubt about it. Psychologists, psychiatrists, and social workers have a lot of good stuff to say about what parents are like. If they do a good evaluation, they can provide extremely useful information. If I was a judge, I'd want it for sure. But when, again, looking at these 5 levels, when the expert goes from some kind of formulation to something like, well, the parent's not fit and therefore should not have custody, or the parent is fit and therefore should have custody, I am very concerned, even if it's an adversarial process. And I think you can see why. Those of you who do this know this, that when you go from the 3rd level to the 4th and 5th levels, you're vaulting into very speculative testimony because you're making predictions. You're trying to hobble together a lot of information. You may have done hours and hours of work on this particular evaluation, but ultimately it's very difficult to know what's going to happen. You know, just the mere fact that a custody evaluation is being ordered by the court can change parental behavior in a major way. And it's hard to predict exactly what that behavioral change would be. So again, it just gets more and more speculative the farther up, or if you look at the slide, the farther down the influential scale you go. So should you never use penultimate or ultimate issue language? I guess I'd never say never. But I'd be very cautious in a report. Less so if it's adversarial, but only if the lawyers are forcing you. You know, if no one asks you the question, why answer it? And again, it's not just because there are moral or ethical reasons for not answering it. There are practical reasons too. If you don't answer it, as I said before, both sides can probably find something like in your opinion. If you're being truly honest and straightforward about what's going on, both sides can probably find something to like in your opinion, and the less likely you'll be subjected to the kind of adversarial cross-examination that none of us enjoy. By the way, I've been subjected to cross-examination. I don't enjoy it either.
You mean that's not why you got into this? For that fun
I like
cross-examination
doing cross-examination. I particularly like cross-examining Randy Otto and trying to make mincemeat of him, though it's difficult. But I don't like being cross-examined myself.
I would have loved to have been a fly on the wall during that. Okay, so our next question is actually one that's really interesting to me as well, because we have discussions about this here in New Mexico. So what is your opinion about offering the opinion at the end versus the beginning of the report? I've seen different preferences in different jurisdictions. I have my own preference, but curious about what you and others think.
Well, if you could somehow prevent the judge from flipping to the last page, I would prefer waiting till the end. The idea being we want the judge to read all the facts before his or her opinion's colored by the first sentence of the report. Well, we all know about this. This is basic psychological knowledge that you get confirmation bias, you get recency effects. A person reads a conclusion and everything they see after that is going to be colored by what they read initially. So I would prefer having the conclusion at the end or avoiding it altogether for all the reasons I've been talking about. That's the short answer to the question.
The next question is, what is your opinion of including the following statement at the end of a forensic mental health assessment report? So open quotes, all of the aforementioned opinions are rendered to a reasonable degree of medical certainty, close quotes. Is it a meaningful or just boilerplate? And how is it received by the court/judge?
Okay, well, those are two different questions. I'll answer the second part first. I think a lot of lawyers are used to that phrase, reasonable medical or reasonable psychological certainty. I don't know where they get them. Well, I know where they get it. They get it from old case law. I don't think most law professors suggest lawyers use this anymore, but in the law, things die hard. Precedent rules. And since it's been done that way, it should continue to be done that way. That's the law for it. I mean, there's some good reasons for precedent, for stare decisis, so-called. But in this particular case, and this gets to the answer to the first part of the question, I think it's a real bad idea. It means nothing. Reasonable medical certainty, reasonable psychological certainty mean absolutely nothing. Unless you want to define it. Oh, I'm 20% sure, I'm 50% sure. But it's just finesse of the question. You should be reasonably certain of everything you say, right? If you've got a caveat, if you're not sure about what you're saying, you should make that clear. So looking at these 5 inference levels again, during the evaluation, the defendant said he was hearing voices. I think he was not malingering when he said that. Why do I think that? Because I administered the SIRS or whatever you did to verify that that he was probably hearing voices. But if you're not absolutely sure, you express the caveat. I'm not absolutely sure, but I'm pretty sure that the person's hearing voices. Then you got a symptom. And I think because of these voices, I think the person is suffering hallucinations. And because of those hallucinations, I think he has schizophrenia. Why do I think that? Because in DSM-5, blah, blah, blah. And you go on from there. If you say it, you should be pretty sure of it. Or if you're not sure, you should express the caveat. Because you know for darn sure a good lawyer is going to come back at you. And if you haven't expressed that caveat, he's going to get you to express it in cross-examination. And it's going to look like you're trying to hide something. But using this language, reasonable medical certainty, reasonable psychological certainty, doesn't help at all. It just adds a gloss that in many ways hides how sure you are or how uncertain you are. So I wouldn't use it. I wouldn't ask my expert witnesses to use it.
Great. Okay, so next one it says, if FRE 704 prohibits testimony on the ultimate issue of insanity, is there a problem offering an opinion in a written report?
Yes, that's a good question. In theory, and to tell you the truth, I do not know the answer to that for sure as a matter of federal law, so I don't want to state that this is the law. I would argue that, yeah, you should not offer that opinion in a report either. However, again, being a lawyer on the other side, I would say, no, 704B contemplates a jury trial. The concern is that juries will be over-influenced by this kind of ultimate issue language. And we don't need to worry about judges being over-influenced. And what would back that up is a constant theme in evidence law. You've all heard about the rules against hearsay, the rules against presenting character evidence. All of those rules exist because we don't think lay people can handle certain kinds of evidence, hearsay, character evidence, and so on. And the same thing arguably is true of Rule 704B. The reason Rule 704B is there is we're worried the juries will take a conclusion a person's insane and run with it. We're not worried that judges will do that. So that's the argument, counter argument. No, you shouldn't put it in the report because of what 704B says on its face or yes, it's perfectly okay, but you should not give oral testimony using that language.
Okay, and it is right at the 1 o'clock hour. So for those of you that need to jump off, the CEU link has been posted in the chat, but we are going to continue on with some more questions if that's okay. So the next one, so says, isn't a fundamental difference between competency and sanity question that ensuring a competent defendant is in the interest of all parties, defense, prosecution, trier of fact, while sanity is perhaps by nature adversarial? What are your thoughts on that?
Okay, so I agree that the competency determination is something that everyone should be very concerned about, judge and prosecution as well as defense, because we want to make sure that the defendant understands the process and can communicate with the attorney. And as I said, judges and prosecutors should be just as worried about this as defense attorneys, because we want to make sure it's a reliable process and a fair process, and a process that has integrity. So in that sense, you could argue there's a difference between competency and insanity. With insanity, it's mainly, it should be a concern of judges and to a less extent prosecutors, but it's mainly a concern of the defense. The defense is the entity that raises the insanity defense and should be most concerned about whether we get it right or not. On the other hand, having said that, we want to make sure that the competency issue is addressed in a fair way. So bottom line, if the adversarial process is necessary to make sure an issue is addressed comprehensively, we should have an adversarial process. And in many competency cases, despite the fact that all parties are interested in the ultimate outcome in a very real way, we should make sure it's addressed in an adversarial process if there's any doubt as to whether or not the person's competent. So I guess that's a long-winded way of saying no. I think a competency issue should be addressed in an adversarial way, as in its adversarial process, as an insanity issue, if there's doubt about competency. We want to make sure that we get it right.
Okay, so someone else had a very similar question, but they had a second part to it. So I'm going to ask the second part. So the first part of the question was about the adversarial nature for competency, and that, you know, we would hope that neither side would be advocating for an incompetent person to be tried. And so the part two of that question is on a similar note, if you believe that, do you believe that there ought to be a mechanism for an incompetent misdemeanant to agree to conditions of release?
Okay, so yeah, on the first part of the question, just to reiterate what I said, I'm assuming that no one wants an incompetent person to be tried, but we still need to get it right. We still need to have an adversarial process to make sure we get it right. Now, on the second point, this is actually moving, I think, to some extent from expert testimony issues to substantive issues of how we should deal with people who are incompetent. And I think I agree with the underlying premise of the question, that it makes no sense to treat a person through the criminal justice system if their only charge is a misdemeanor or even a low-level felony. I think we ought to divert most, if not all, those people out of the criminal justice system into the civil system if, and this is a big if there are viable treatment programs on the civil side. Because once they get in the criminal justice system, all sorts of things can happen that are not good for anybody. Not only not good for the putative defendant, but not good for the system. And it creates inefficiencies that in many ways bollocks up the entire criminal justice system. Unfortunately, as many of you know, the incompetency plea is often used as a way of getting a person who has a mental disability treatment that they can't get elsewhere. And that's one of the reasons we have the situation we have in many jurisdictions where police who pick up someone on the street who has a mental disability are funneling them through the criminal justice system as opposed to the civil system, even though ideally it should be the civil system, not the criminal system, that is taking care of these folks. So the short answer to your question, yes, there should be diversion in a lot of these cases. And I don't care if they're incompetent. criminal justice should not be the issue in those cases.
So one of the questions is for references. So I know you have a reference slide, but they were asking if you have any specific books that you would recommend for a novice to get more acquainted with this topic.
Yeah, Stan Brodsky has done a great book on being an expert witness, and I should have put this on here, given the fact that I'm expanding the subject matter to expert testimony generally. These references here are almost all focused on the ultimate issue stuff. Though obviously the Gary Milton book deals a lot with expert testimony writ large. In fact, there's a whole chapter based on report writing and the whole chapter based on expert testimony, and a third chapter which has sample reports. So there are 3 full chapters constituting over 100 pages on expert testimony. But Stan Brodsky has, I think, one of the classic books, and I can't remember the title of it, unfortunately, on expert testimony. Of course, Tom Grisso, he's written a book about everything, and about having to do with forensic mental health. And he has some good stuff, but I think it's primarily focused on very psychological instruments as opposed to expert testimony generally. And I'm blocking, I don't know if there's any vehicle for doing this, Simone, but I could certainly send along 1 or 2 other references, but I'm blocking on specific references right now.
Yeah, absolutely. You can send us references and we can definitely send those along when we send the slides. And
I have my office right here, but I want to take time to look for them.
Sure. Yeah, you could definitely send that when we can send it along with your slides. Okay, so the next question is, what is your opinion on ultimate issue testimony that rather than asking us to opine on issues related to a person's present mental state, e.g. competency, or past mental state, e.g. sanity, is asking us to predict the future, for example, violence risk assessment predictions. So I know we talked a little bit about this when we were talking about the sex offender statute. So it's asking if your opinions differ if there is no statutory definition for what we are being asked to predict. For example, if the statute referenced determining whether the individual has a substantial likelihood of committing future acts of violence, but does not define substantial likelihood.
Okay, this does feed off exactly what I was talking about before. What the hell does substantial likelihood mean?
Right.
And again, in fairness to the law, 20 years ago, what was the law supposed to say? Right? We had no way of quantifying, any empirical way of quantifying what likelihood or substantial likelihood meant or what probability meant. Now we have actuarial instruments, and some of you might not like actuarial instruments, but they do at least provide us with some kind of quantification. And so I think it behooves the law to come up with something a little bit more specific, but not only with respect to probability. I think there are 4 issues to be more specific in terms of what I talked about before. There's the probability issue, but there's also the probability of what outcome? Violent crime, any crime, misdemeanors as well as felonies, or just violent crime. What kind of violent crime? Sexually violent crime, simple assaults, the VRAG, which many of you know about, the HCR 20, which many of you know about. They were both validated using simple assault as a recidivism event. Well, if I'm a lawyer in a death penalty case, I don't care at all that my client has a 90% chance, that's the probability issue, 90% chance of committing a simple assault. I would argue that's irrelevant in a capital case or a sexually violent predator case. What's relevant is whether they can commit a very violent crime if we don't put them in prison for the rest of their life, or if we give them life without parole or life with parole, as opposed to the death penalty. That's the second issue. Third, during what period of time? Okay? In civil commitment, it should be a high probability of a violent act defined in some way during a short period of time. Why? Because civil commitment is about imminent dangerousness, not dangerousness or recidivism 4 years from now. Capital case, different story. Then the timeline is much longer. And finally, and this is in many ways the most important thing, probability of what outcome during what time period in the absence of what kind of intervention. Imprisonment is not always the right way to go. In fact, a lot of times, as many of you know, imprisonment is the worst way to go if what you're trying to do is reduce risk. In fact, alternatives to imprisonment are much better in many cases, combined with substance abuse treatment programs and so on. Again, the law has done a very poor job of identifying any of the definitions of those four things. But that doesn't mean you as a clinician can't provide that information. Do it. There's nothing to prevent you from doing it. And who knows, maybe the lawyers will pay attention. Now, maybe they'll ignore it completely, but hopefully they'll pay attention and maybe ask you some questions about it. And maybe we'll get the ball rolling in terms of this jurisprudence of risk that I've been talking about.
All right, so I think we'll do one more question and then we'll not take up any more of your time. So this question is, I'm very interested in your thoughts on why this is such a perpetually hotly debated topic in forensic psychology, with people holding very strong opinions on both sides. So in your opinion, is there a gray area in this field that we could be embracing?
Well, yeah, the gray area is what I say here, and I think you could call it a finesse, but I think it's the right way to go. If you got an adversarial process, go ahead and do it, especially if the law is demanding the information and lawyers really want it, but use this kind of language. If it's a non-adversarial proceeding, avoid it if you can. And sometimes you can't. That's my, if you will, gray area response. I mentioned Clark versus Arizona. If this is the last question, I want to say something about that because it feeds directly off what I just got through saying. Many of you know Clark versus Arizona. That was the case where the Supreme Court dealt with the so-called diminished capacity or mens rea testimony issue. It was a case where an individual shot an officer of the law. Well, you know, when you shoot a cop, you're in big trouble. Clark was charged with capital murder and was convicted of it. He tried to assert an insane defense. That didn't work. But he also asserted a lack of mens rea defense, which is different, as many of you know, from insane defense. It's not an assertion that I was crazy at the time of the offense. It's an assertion that he lacked the mens rea, the mental state element of the crime of capital murder. In this case, he was saying, I thought that what I shot was a space alien. I did not think I was shooting a person. I thought I was shooting a space alien. The law of homicide has an element of the offense, intent to kill a human. It's called homicide, right? Killing a Homo sapien. Killing a space alien is not a crime in any state. If you intend to kill a space alien, you have not committed a crime. Now, of course, that is a kind of argument that a jury might laugh out of the courtroom, but that was the argument that Clark was trying to make. And saying, and what happened is Clark presented an expert witness who testified at all 5 levels, testified about the facts. Clark thought he was seeing space aliens. The symptoms, he was hallucinating. Diagnosis, schizophrenia, penultimate language. He had no clue what was going on, but here on mens rea, he did not intend to kill a human. That's the ultimate language that you would use in a mens rea case. Not he was insane, as it says here, but rather he did not have the mens rea for the offense of capital murder. That was the expert's ultimate issue testimony. Supreme Court said that it's permissible as a matter of constitutional law to limit the expert to inference level number 1. And it agreed with Stephen Morris in this particular context, that you can limit an expert to this level of testimony. You can't even go to symptoms, much less diagnosis, penultimate issue testimony. Okay? Now, does that mean that you're always barred from doing this when you're talking about mens rea? No. All that Clark was about was what the Constitution allows a state to do. What Clark said, it's permissible for a state to limit expert who's testifying about mens rea to this level. But states can certainly allow individuals to talk about more than that, and most states do, by the way. Arizona is relatively unusual in that sense, and which means that, and this gets to the gray area point, I think experts should feel perfectly okay about doing the first 3 levels, even in a mens rea case. I think in these latter 2, everything I said before still applies. Okay, saying the guy did not intend to kill a human being, therefore did not have the mens rea, problematic. But if it's a fully blown adversarial proceeding and you make it clear, as I've said over and over again, that's just your interpretation of the legal standard, then you should be able to do it.
All right. So I think with that, right on the 15-minute pass, the 15 minutes that I asked you if you'd be willing to spare for us. So thank you so much for agreeing to do this. This was wonderful. I know everybody really enjoyed it. So I appreciate you taking the time. I think we're going to hang on just for a couple more minutes for folks to grab that CEU link.
So
Dr.
great
Slobogin.
questions. Thanks very much.
Yeah, thank you so much. You're welcome to jump off if you like. We'll just hang out here so people can
All
get
right.
their credits. Thanks again.
Thanks, Chris.
Thanks.
Thanks, Cara. Bye, Jeff. I think we're good. I think we're gonna log off because we've had the CE link up
For a while.
Yeah. All right. Thanks, everybody. Have a good day.
Thanks, everyone. Bye.
Bye.